Hello, you're watching Addleshaw Goddard's Employment Channel on the 31st of August. In this week's headlines, how far can you go to stop an ex-director from soliciting clients? We see what the High Court said. Ever wondered what could be the worst job ever? Well, ACAS finds it's having to tell someone that they're redundant. Finally, as the football season starts, we find an employee who's just received £44,000 after being bullied at work for not liking football. So, first up today then is the case of Safety Net Security and Coppage, a case about whether an employer could enforce a 6-month non-solicitation clause which stopped an ex-director from approaching anyone who'd been a customer of the company during his employment. Mr. Coppage was employed for 4 years as a business development director of Safety Net, which was a small business providing security services. He had a prominent role in the business and contact with all customers. In fact, many saw him as the face of the business. Mr. Coppage chose to resign after he was put at risk during a redundancy consultation. The next day, a similar company to Safety Net was set up, and shortly afterwards, 5 of Safety Net's clients moved to this new company. Although Mr. Coppage hadn't set this company up, Safety Net alleged that he was the controlling mind and therefore that he'd breached a covenant in his contract requiring him not to approach any of Safety Net's customers for at least 6 months. Generally, restrictive covenants are void unless employers can show a legitimate business interest and that they've gone no further than is reasonable to protect that interest. Usually non-solicitation clauses like this one should be limited to customers and clients who the employee actually dealt with during a specific period before termination. This aims to avoid the clause being too wide to be enforceable. In fact, this is exactly what Mr. Coppage argued, that the covenant in his contract was too wide to be enforceable, as it should have been restricted to customers that he'd actually dealt with during the last 12 months of his employment. However, non-solicitation clauses don't always need to be limited to customers that employees had contact with, if employers are intending to protect either a general customer base or the general goodwill of the business. And there's got to be a well thought out time limit in addition. Here the High Court found that Mr. Coppage's covenant was enforceable. It was sufficiently limited by the 6-month time period and in the customers that it applied to. The court found that Safety Net couldn't limit that clause any further because this would then remove the protection that they needed. And this was because Mr. Coppage was such a key figure in their operation and marketed as the face of the business. So many of us might have assumed that a non-solicitation clause like this, which applied to all clients and all customers, would be unenforceable. Why then did the High Court find otherwise? Well, it appears that Mr. Coppage's seniority, his integral role, and the relatively small size of Safety Net were all key factors here, as well as the parties' approach to the litigation as well. Safety Net's CEO was praised for giving his evidence openly and in a straightforward manner, whereas Mr. Coppage was found to be unhelpful and closed in his answers, as well as guilty of misleading the court, deliberately deleting incriminating text messages, and lying on his Facebook page as well. The High Court also gave guidance on how employers should assess the enforceability of non-solicitation clauses. I therefore asked Jamie Hamnett, a partner in Addleshaw Goddard's employment group, what he made of the outcome of this case.
Thanks, Helen. I suppose it brings home 2 key points. Firstly, the actual construction of the clause is going to be very important. So how is it drafted? But it also drives home the importance of considering the clause in context. So when we look at this particular case, we've got to bear in mind that the gentleman in question was in a relatively small organisation. And the customers, I think as you've described, saw him as the face of the business. And so whilst he might not have known all of the customers he was subsequently seeking to solicit, he knew lots of them, and that was clearly an issue in the judge's mind. Contrast that with a business which is huge, where the the individual in question has only had contact with a very limited number of them, and the outcome of the case might have been very different.
Oh, thanks, Jamie. Is there anything else useful from the case that gives employers guidance in this area?
Yes. I think what I would say is, as we often say to clients when considering the drafting of restrictive covenants, try not to adopt a restrict all for as longest period of time as possible approach. Often we get clients who want to impose restrictions for a very long period of time without thinking about whether or not that is going to be enforceable. And really, the overarching advice must be, think about what's necessary in each case and how important it is in relation to the individual in question. Where I get very nervous, for example, is where a client wants us to come up with a bank of precedents which it's going to apply to as many employees as possible. In those circumstances, the advice has to be they're far less likely to be enforceable than it would be if you were picking, say, a senior management team and preparing bespoke covenants for not just the team, but maybe for each individual within that team. Whilst this case was fact-specific, the court gave some helpful guidance which could be considered in a more general context in terms of what solicitation amounts to. And the judge in this case said that solicitation was more likely to be direct and targeted approaches to contacts than general advertising or putting up a website, for example, advertising in the general media.
Thanks, Jamie. Next, what's the worst job you've ever had? Research carried out for ACAS has revealed that those who have to break the news of proposed redundancies find this the worst job ever. The results of the research were so startling that ACAS has gone on to update its redundancy handling note. These changes recognise that the people who ACAS call the tellers have a very difficult role to play. They are often far more than just messengers and are possibly the most important people in delivering any organisation's downsizing goals. As a result, it's important for organisations to think about this role, how to choose the right people and ways to support them. The research was conducted by carrying out 50 in-depth interviews between 2010 and 2012 across a range of public and private sector organisations. 30 of the tellers were in HR and the other 20 were in other management functions. Those involved described the emotional impact of their role as traumatic, nerve-wracking, dreadful, very upsetting, hideous and stressful. It certainly doesn't sound like a dream job so far. The closer the working relationship with those affected, the more difficult the role became. Work overload was also a common issue, particularly amongst line managers, who were usually required to carry out the role of the teller in addition to their usual management duties. As a result, ACAS suggests that employers think carefully about who should break the news. Those closest to the employees at risk of losing their jobs may be the ones who find it the hardest. Whoever does take on the role should be involved in the overall downsizing process right from the beginning, as it'll make them more understanding and better communicators. Line managers in HR will need training and support to help them cope with the emotional and psychological demands of letting people go. Again, I asked Jamie Hamnett for his views on the importance of this subject for employers.
Thanks, Helen. From experience, I think this is hugely important. And I'm not surprised to see the ACAS guidance, and I was interested to read the CIBD paper on the same topic. I think that thinking about who the tellers should be and what they need should be a key part of the planning stage. Getting a redundancy process right, dare I say it, isn't hugely complicated. The law's quite helpful, it's quite prescriptive. Certainly the ACAS guide to redundancy handling is hugely helpful in terms of the process and the procedure which you need to follow. Identifying the tellers and making sure that they're properly equipped to do a good job, I think is perhaps slightly more challenging, but if you get it right, one of the keys to a successful redundancy process. So at the outset, think about who the teller should be, and that's for me is balancing not only who do you think the best person for the job is, on the one hand, but on the other hand, who will the employees who are affected by the redundancy situation expect to hear from? It's all very well and good rolling out a mouthpiece, but if that's somebody who the employees aren't expecting to hear from, that separately can do damage to the credibility of the organisation. The teller needs to be somebody who not only understands the rationale for the redundancy situation, but feels, if I can say it like this, comfortable enough to place that in the context of what the business is trying to achieve overall and in a manner which is consistent with its values. What you don't want is somebody coming in who really hasn't got the first idea as to what the overall people policy is and delivering a message which is contra to everything which the business is trying to achieve. And I think the third part of the planning stage when looking at tellers is thinking sort of very specifically about what support they need. Training perhaps in the first instance, but also thinking about support which they need along the way. Again, speaking from experience, whilst it's really helpful to make sure that your tellers are on message in terms of the scripts and the numbers and the process, they need to feel supported throughout the process too. And even the most experienced HR managers and line managers, people who have years of people management experience, can find this process really, really challenging.
And finally, with the new football season upon us, a business in Newcastle has received perhaps a timely reminder to stop football-related banter in the workplace from getting out of hand. Yes, a married salesman who was told by colleagues that he was gay because he didn't like football has just been awarded £44,000 by an employment tribunal who found that his boss and colleagues, who were all avid Newcastle United fans, were guilty of harassment for taunting him in this way. In a nation with a long history of enjoying the great game, football discussions are pretty commonplace at work, but employers do have a duty to ensure that any discussions don't go too far. For example, under the Equality Act, there's a claim waiting if it gets to a point where someone's suffered unwanted conduct related to a protected characteristic, so for example sex, race or sexual orientation, which has the purpose or effect of violating their dignity or creating an intimidating, hostile, degrading, humiliating or offensive environment. If you'd like more advice on how best to manage banter like this in the workplace, please do give me a call. Elsewhere, and in a different league, you may remember the case of McCammon and Gillingham FC, reported in our programme on the 9th of August, where a tribunal found that a black footballer had been unfairly sacked by his club after suffering racial victimisation. Mark McCammon was awarded over £66,000 in a landmark legal victory after it was found that he had been put through hell at League Two Gillingham in being treated differently from white players. Gillingham, who'd originally said that they were staggered by the judgment in McCammon's favour because they'd employed thousands of staff of different races without complaint, have now lodged an appeal against the judgment. All eyes in the football world are likely to be on this one, so we'll keep you updated. So to wrap up for today, I'll leave you again with this week's headlines. How far can you go to stop an ex-director from soliciting clients? Well, the High Court finds that wider non-solicitation clauses can be enforceable in some circumstances. If you need any advice on this, please do give either Jamie or I a call. If you've ever wondered what could be the worst job ever, well, ACAS finds it's those who have to tell others that they're being made redundant and has updated its redundancy handling guide as a result. Finally, at the start of the football season, one employee has received £44,000 after being bullied for not liking football. So that's all for today from Addleshaw Goddard's Employment Channel. Thank you for watching and goodbye.